Good afternoon, everyone, and welcome to CAI Illinois Q&A webinar entitled The Practical and Legal Considerations in Holding Open Remote Board Meetings During COVID-19. My name is John Gocke, and I have been a Homeowner Leader Education Committee member for a little less than 2 years for CAI Illinois, and this will be the third webinar that I've helped put on as a moderator in 2020. So hopefully the third time's the charm. In real life, I'm a grandfather of 6, husband of 45 years, and have just been reelected to the homeowner board of the Westchester Club for my second term in Illinois, in Westchester, Illinois. I welcome you to this on behalf of CAI Illinois and the other panelists, Kerry Bartell and Danette Smusz, who will introduce themselves in a moment. But first I wanted to take a few moments to introduce you to the format for today's meeting. Basically, I will serve as the homeowner moderator of this august panel. The 2 other members are august, not myself. And I will be serving as moderator of this panel. I'm not an expert in any specific legal or association matters, but rather am an interested volunteer for CAI Illinois who became involved in this organization primarily 2 years ago to help promote and improve education for homeowner leaders and homeowner members, board members and owners of your own associations, just like myself, who wanted to learn more about how to become a better board member. So during the presentation today, if you have any questions or would like me to ask the other panelists, please use the chat bar to communicate those, and we will try to get your questions answered either during portions of the presentation or the Q&A session. At the end of this hour, you will be given an opportunity to download a couple of handouts that our panelists, Kerry and Danette, have put together for you, and we'll remind you about that at the end. Now I'd like to first ask Kerry Bartell, our distinguished regional attorney, specializing in HOA and condo matters, and then ask Danette to each say a few words introducing themselves before we get into the meat of the matter. Kerry?
Sure. Well, I'm a little nervous now that I had that introduction. Thank you, John. My name is Kerry Bartell. I'm a principal with the law firm of Kovitz, Shifrin, Nesbit. I've been practicing in association law for over 20 years, although I hate saying that because it makes me feel old. But I've been around for a while, and this is basically all I do is work with boards of community associations to make sure that they're some of the common pitfalls. But I also, on my other side of my head, have been CAI for about the same, a little less than 20 years. I did serve on the board of directors for CAI for 6 years, where I was president for 2 of those years, and have been active on committees for much of that time. I think, CAI is a fantastic resource for both our clients and managers and individual board members. So it is a pleasure to be with you guys today and helping out. Turn it over to Danette.
Hello, everyone. My name is Danette Smusz. I'm Executive Vice President of Foster Premier, which is a property management firm. I have been in this industry and with Foster Premier for 25 years, which when I say that aloud, I can't believe that either. It's been a pleasure, though, watching this industry grow and multiply and change. It's ever changing. On my personal side, I have 2 children, which I'm incredibly grateful that they are independent and old enough where I don't have to help them with virtual learning. That's probably the most thing I'm grateful for this year. I'm honored to be here, and I really hope to help you manage through some of these unprecedented times and just be able to conduct business and help you with your associations and boards and meetings. Thank you for having me.
Great. Kerry, how would you like to start us off, please? And, we're going to start off with things like how to plan for a meeting, how to get ready for a meeting, how to notice a meeting, etc. Why don't you take us off and start us off there?
Sure. So, when we were preparing for today, under John's great leadership, we thought that we would kind of start with the legal parameters and kind of what you can and can't do in order to hold your meetings, both board meetings and owners meetings. And then Danette's going to kind of do some practical day-to-day suggestions after we make sure that everybody's doing this correctly. So, the first thing that an association needs to do in order to hold a proper meeting is to make sure that the notice is in compliance with the statute and to a lesser extent, your declaration and bylaws. So when we're talking about a board meeting, which is the business meeting of the board, sort of your normal, what most people think of as their normal meetings, the statute, both for condominium associations and under CICA, which is the Common Interest Community Association Act, governs townhomes, homeowners associations, pretty much everybody but condos. You need 48 hours notice before the board meeting, and that notice needs to be mailed or delivered to every owner, as well as posted in any common entranceways or common areas. So if you have a building that has 7 or more entrances, it needs to be posted there. If you have a clubhouse, typically you'll post it in the clubhouse. So it really depends on the layout of your association with regard to the posting requirement. If you're talking about an annual meeting, which is your owners meeting, election meeting, this also, owners meetings also include budget meeting, but then also if you're going to be adopting rules and regulations, special assessment, or your an amendment to the declaration, those owners meetings require 10 to 30 days notice beforehand. So it is a little bit of a different, longer requirement. And keep in mind that the notice has to state the time, the place, and the purpose of the meeting. If it is just your regular board meeting, the purpose can just be a board meeting. If you are calling a special board meeting, then you need to state the specific special purpose. If it's a special assessment, rules and regulations, that needs to be specific as well. So keep in mind, the notice is critical. So you need to make sure that those go out and that you keep proof that the notice was sent, because that can affect the legitimacy of the decisions made at any particular meeting.
Kerry, along these lines, we had one question early. Actually, I formulated the same question in my mind. You had mentioned the different day requirements for the notice, depending on the type of the meeting. What is the operational definition of delivered? Does it mean you mail it on this date, they get it on this date, you put it up on this date? How do you operationally define that?
So that's a really good question. We get that a lot. And the way that the statute reads, it's that it is sent or put in the mail if you're mailing it, or posted if you're going to post it. It is the date that the board submits it to the owners. There's no requirement. There's no mention of a requirement as to when an owner needs to receive it. For annual meetings or owners meetings, 10 to 30 days, people are going to get it before the meeting. But that's kind of the rub with board meetings, because you could mail it. And, if you live in Chicago, you're not getting that mailing within 48 hours. But that's not our concern. That's not the board's concern. You just have to make sure that it's sent out 48 hours beforehand. The other thing, too, that I want to mention is with regard to email notices, because I know we get that issue a lot as well. You can have email communication or email notices, but you have to, under both statutes, make sure that the board has to adopt the rules providing for email notifications. And the critical second part is that each and every owner has to opt in order to receive email notifications. Your attorney should be able to provide you with a form for that opt-in for your home ownership. The fact that somebody gave you their email 5 years ago does not count as an opt-in. They have to affirmatively state that they want things mailed to them via email.
So let me clarify that. Would you do that opting in on an annual basis or every 2 years or how?
You only need to opt in once, or an owner only needs to opt in once. And the way that we draft our forms, it is on the owner to notify us if the email address changes. We don't have to continue to confirm. And often what we say is that if we send an email 3 times and it comes back bounced or no longer, accepts emails, then we will consider that the owner has negated that email or withdrawn their opt-in. So that at that point, they would have to send in a new form.
So one other clarifying question, if I may, on this topic. Suppose you have 100 owners and you have 95 emails and you have 5 people that haven't supplied you with emails or haven't opted in. Are you compliant if you email 95 and snail mail the other 5?
That's exactly what you need to do.
Okay.
Yeah. So, when email notices first sort of became available under the statute to associations, I had some associations that said, we're not doing it because of the logistical issue of keeping 2 separate lists, right? You have to keep a list of who's opted in and a list of who hasn't, and send it the appropriate way to any given owner. At this point now, and particularly given COVID, a lot of people have started to adopt those rules.
Someone just asked about opting in. Can you opt in with an electronic form as well as a paper form?
We need those original signatures on file, because understand that the notice requirement is critical to so many other things that the board then does at that meeting, right? If the notice is improper, it negates the legitimacy of the meeting. So I always take the position that we need an original signature back. Again, given COVID and sort of all the craziness that has ensued with that, I think if an owner fills out the form, scans it back in, and emails it back to the board or the manager that way, so that we can print out the form, right? The executed form, then that's sufficient. Okay. But an email saying, hey, I'm opting in, that's not going to work.
Okay. Yep. Very good. Very good. Are there any other legal guidelines that we should talk about before we go on to any other topics?
No, I think that's a good summary.
Okay. And we also mentioned that there are annual meetings where elections take place, and there are quarterly meetings, and there also can be special member meetings, can there not?
Mm-hmm. Yes.
Is there any difference about noticing special member meetings?
So the notice requirements are going to be the same, whether it's a board meeting, special board meeting, a regular owners meeting, or a special owners meeting. It's 48 hours versus 10 to 30 days. But what happens with the notice, I think I sort of maybe glanced over it before, is that if it's a regular board meeting, you're typically not stating a purpose. Some associations include the agenda. You are certainly not required to do that. But if you have a special board meeting, then you need to state the purpose of that special board meeting. With special owners meetings, you really don't have those unless it's for a specific purpose. So the purpose is going to be stated. Those would be special assessment, your budget meeting, rules and regulations, and amendments. So those for special owners meetings, you're going to usually state the purpose just because the nature of what you're doing requires that.
For instance, if I could give an example, if you wanted to hold an educational session for owners on a given topic, that would be a special meeting, but that would be the purpose of the meeting, correct?
Correct. That's right. Mm-hmm.
Very good. Very good. Danette, we're going to turn it over to you and ask for your input on planning for meetings and setting up meetings and building agendas and doing it the right way, the legal way, the proper way, etc. Take it away.
Every meeting needs an agenda. So I think planning to have your agenda is your first step, of course. I think it's important that about a week before the meeting or a week and a half before the meeting, whether you're a manager or whether you're self-managed, somebody needs to be the collector of the agenda items. I think your agenda needs to be a living, breathing document that you maintain every week. Take a glance at it, see what you need to add, because coming up with an agenda a day or two before the meeting is never a good plan, and most likely you'll lose some of the things that you need to have on that agenda. I would suggest sending an email to all of the board members just stating that you're preparing for the meeting and you want to get everybody's input on what should be on that agenda, and then being prepared to discuss all of those agenda items. The board members should kind of make sure they all agree with what is on that agenda. You don't want to put things on the agenda that aren't meaningful, or that maybe the community isn't interested yet, or you're not prepared to talk about yet. Agendas should be more meaningful and not just be filled and stuffed with information. I mean, you don't want a 3-page agenda that is just a bunch of fluff, because you're going to lose your audience. You could lose your board members. You just want to make sure that what's on that agenda are things that truly the board needs to discuss or needs to decide upon. I did include a sample agenda that you can all download later. It's a really robust agenda. It's probably one of the biggest communities that we have that just has a little bit of everything in there. But that agenda will be a good start I keep mine in a Word document so that I can add to it as things come up over each week, send a draft form out to the board prior to the meeting, and any pertinent information that board member needs to review prior to the meeting, so that everybody feels like when they're going into the meeting, they're well informed. I think the board needs to make sure they know what's on that agenda and be prepared to discuss it and not be caught off guard. Now, when you build your agenda, there's a few things I think a lot of people have questions on, which is the items that need to be on an agenda. Some of the things I think Kerry also has on her downloaded forms that you can download after this. But obviously you need a roll call. You need to make sure you have a quorum of the board. Open forum is something that I think can be a little flexible. You have to have an open forum, whether you put it in the beginning of the meeting or the end of the meeting. I think that really is determined by your community, by your board, by the personality of your residents. When doing open forum, especially when you're doing it virtually, I think we've all stumbled the last few months of how to handle open forums. Each way can work. Each way can be successful. We've had where when we send out the meeting of the notice, it's important to clearly outline to the residents how you're going to handle an open forum. If you choose to handle it where they need to turn in any questions in advance, that needs to be upfront to the residents, that during open forum, we will be reading any questions that any residents may have. This would prevent you from having to open up mics or try to monitor a chat box, because if you do have a large meeting with a lot of attendance, that can kind of become a managed nightmare if you don't have a second, person who's outside of attending the meeting monitoring the chat box. If you are going to allow chat box, then you just outline that in your meeting notice, that open forum will be handled by chat box. I think it's important to just remind people to be respectful within that chat box, because it's amazing. People can be just as disrespectful via chat as they can live. So it's good to just kind of a gentle reminder to people that if you want to type in the chat box, please be respectful, and we'll try to get out to all of your questions. If you are going to open up mics, just be ready to monitor that, and hopefully you can call on people individually that, at this point we're going to open up open forum to the residents. We'll open up your mics, and if you have a question, please address it at this time. The board is under no obligation to give you answers off the cuff, and I don't think boards should do that. I think if it's something, maybe a procedure or a rule or regulation, then of course that can be answered. But if it's something that the board does need to discuss, I think it's important for the board to state, that's something we'll put on our next agenda and we'll discuss as a board so that they can do their due diligence and get their information in order. John, any questions before I continue?
I think you did a great job. I have one question that popped up while you were talking that kind of is a bridge between you and Kerry. So I want to get to that question, and that is a practical one. Going back to meeting announcements, someone mentioned that, and I think this is probably in a condo building, they mentioned that if you have a monthly meeting anyway, and you always post the notice in a common place, do you still have to mail it every month to everybody?
Yes. Yes. The mailing, whether it's electronic or, in the mail, or even, you could even door drop too. Don't forget, you can, if you're in a condo building, I have some condos that rather than spend the mailing cost, they'll just, somebody's designated to go drop it off, and slip it under everybody's door. That's fine too. But the posting, particularly on a website or a community board, that is not sufficient. That is not notice, because you cannot guarantee that everybody's going to log on and check it within the time frame stated. So you have to look at it in terms of this way. If I'm in court and I have to verify to the judge that the notice was sent to all owners, could you do that if you just posted it on a website? You can't. You can't guarantee that everybody checked that website. You could, as a manager or a board member, get up and say, yes, I placed it into the mail or for all 100 of our residents. And that's sufficient, right? So think of it in those terms.
Mm-hmm. Danette, thank you, Kerry. Danette, going back to you, I wanted to ask you about the homeowners' comments. You touched on that, and there's a couple of, I think, overarching philosophies about when's the best time to have that quote-unquote open forum or homeowners' comments. The couple things I have heard is people say, well, if you send out the agenda ahead of time, maybe that would promote a lot of questions prior to getting into the individual agenda items. So if you don't send out the agenda ahead of time, maybe that would be a situation, I would think, that might promote itself better to having questions later in the meeting. Can you give us your thoughts on that?
I've seen it done both ways. I think it depends on the organization of your board, because most boards may not have their agenda complete by the time the mailing has to legally be sent out. I do have some communities that do post their agendas and send it out to the community ahead of time. I would say a majority of my communities don't, because the agenda isn't final yet. As for when the open forum is, I think it really depends on the community. I have some that do it right off the bat. They open the meeting up, call it to order, do your roll call, and then they do an open forum. I have some that do two. They'll do an open forum in the beginning and ask people, you've reviewed the agenda. If you have any questions on the agenda, now's your time to speak. And then they'll do another one at the end of the meeting and ask if there's any additional questions or concerns from the community. I've seen the open forum on all areas of an agenda.
Okay, very good. And you don't have a preference for which one is better?
I think it depends on the community.
Okay.
I agree.
Okay.
They all do it. Everybody does it.
I would love to just say it's this time, but depends.
This is an ongoing debate, right? And I think there's pros and cons to both.
So, Danette, going back to building an agenda, what are your keys to building an agenda? The things that you have learned over the years that have helped you successfully craft an agenda for your clients. You obviously have some best practices, and I'm sure others may or may not. And so let's hear what yours are, please.
Oh gosh, I think it's building an agenda. The best course of action is always to think about the future, because you don't want to be reliving the past and approving things that you've had to do because you weren't prepared. So right now, I think if you're building your next meeting agenda, it should be discussing more spring items so that you're prepared for the spring, your landscaping, your proposals, any landscape improvements you plan to make. If you do have a clubhouse and pool, how you plan to get that open this summer. So you should be trying to plan your agenda for what's coming up in the future. But we know that isn't always how it happens. Sometimes we're putting fires out constantly, and we're having to ratify things that were done. I just think it's really best to keep an agenda. I mean, I have a file for each of my communities, and I will pull up that agenda and I'll be typing things in like, okay, we need to make sure that we get our landscape proposals in place and get those prepared and those proposals sent to the board for review.
Okay. I'm going to ask each of you to describe in the most succinct but carefully crafted words you can how you now recommend to your clients and homeowner associations how to handle the quote-unquote remote meeting differently from the in-person prior meetings that we're all used to from the past. First, I'm going to turn it over to Kerry.
Yeah, sure. So I think, first and foremost, it is okay for boards to conduct both their annual meeting and their board meetings on Zoom or some video conference platform. I'll use Zoom just because it's the one that will come out of my mouth first. But, the Illinois Not-for-Profit Corporation Act provides that, you can participate via video conference and also conference call, although I think that's even harder to navigate, particularly when you have homeowners on that call. But it is an acceptable platform. And the idea is that everybody on the call needs to be able to hear everybody else who is participating on the call and vice versa. So it has to be a speaker system, right? You can't have someone on the phone reiterating what somebody else on the phone is saying. Everybody has to hear everybody. So once we get past sort of the legalities of the Zoom, to your question, what has changed? So I think not a lot actually should be changing. Your notice requirements are the same. Your quorum requirements are the same if it's a board meeting or an owner's meeting. And, developing the agenda, as Danette suggested, that should stay the same. I think what ends up changing is really just the sort of the on-day process. So if you're talking about a board meeting, only the board should be unmuted until you get to that owner forum. And then depending on how you handle the owner forum, maybe it's submitting questions ahead of time. Maybe they can only participate through the chat. In my experience, having done now too many Zoom meetings in the last 9 months, some way to permit owners to submit their questions in writing as opposed to live on a Zoom call is just easier. As I'm sure we've all experienced, if everybody's unmuted, it's very difficult with background noise and somebody's dog is barking and blah, 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 whatever. Everything's going on. It becomes very difficult to hear. So I always recommend either questions ahead of time or the chat feature. But the content and how that meeting moves forward is really the same. For an annual election, it's a little bit more detailed, so maybe we'll deal with that in a second. But I do want to take the opportunity to caution about a pitfall that I see happen more often than it should. And that is when we're on Zoom calls, particularly in an executive session Zoom. So these are closed sessions of the board, one of the permitted topics to be discussed confidentially amongst the board member. You have your board members on the Zoom, and in comes my husband to bring me a cup of coffee, right? But then he lingers in the background and he's hanging out, doing what he's doing, and then he leaves 10 minutes later. Nobody should be lingering in the background when you're on executive session calls. These are private and confidential amongst the board members. And just because we're all in our own houses doesn't negate that need for confidentiality. So if you are going to be on an executive session call, when I'm on like today, there's a sign on my door to my children and my husband that says, "Do not enter on a conference call." So you really need to find a private space for you to have these executive session board meetings so that you're protecting the confidentiality for the association.
So it's really tantamount to like a doctor, patient, or lawyer client confidentiality issue, correct?
That's right. And, think about it. If you're meeting live with your board to have an executive session, your husband's not sitting in the room with you, right? Or your wife or your son or your daughter. It should be that same sense of it's just the board on that video call.
It's HIPAA compliant.
Yeah, right. And so, as an attorney, when I see somebody's family member walking around in the background and I'm providing legal advice, that's of great concern to me because I only have attorney-client privilege with the board members, not their family. So you really need to be aware of that.
There was a question on the chat just a minute ago. I'm going to ask to both of you, probably maybe Kerry to get this for sure. The question was about does the open forum session, the resident comment section, apply to condos as well as to HOAs? There was a comment made that someone thought it was only related to SICA. Is that true?
Yeah, so SICA requires that an open session for the homeowners is on every agenda of every board meeting. For condos, that language is not in there under the Condo Act, but it is my recommendation that is included in every regularly scheduled board meeting. If you have a special board meeting for a condo, maybe that's not necessary, but for regular board meetings, I recommend that you do that as well.
Okay, very good. Let me take a quick gander here at some of the questions. I think we got most of those questions answered. So now let's go to the topic of minutes. And I wanted to ask both of you how you each recommend handling minutes of the different types of meetings. Or is that premature? Because Kerry, I recall you saying you wanted to talk about something about the annual vote.
Oh, yes. Let's talk about annual meetings real quick. And then minutes, I think, are a very important topic. And I'm going to, I'll give the boring side of minutes, but Danette probably has some more practical tips than I do. So with regard to the annual meeting, I think that this has been the single biggest change with regard to meetings with the pandemic and the stay-at-home orders. This is really where boards have had to shift process. So I just wanted to kind of give a brief discussion of how and what that should look like. So again, with your annual election, the notice is the same. The notice requirements are the same. Your quorum requirements are the same. It is 20% for condos, 20% for SICA associations. And if you use absentee ballots, electronic ballots, or even proxies, that part of the process really doesn't change all that much. I have seen a lot of associations who, again, were adverse to electronic ballots or absentee ballots before start to want to develop those rules because it does make it easier. But you can still use a proxy. What is really changing is the in-person nature of the annual election. And the reason for that is due to the stay-at-home orders, we can't have more than 10 people in a room. And for many associations, you have 5 board members, you have the property manager, maybe you have your attorney. So you're stuck with 3 spots for people to come, and that's not sufficient. So what we have to change is that in-person portion of the annual election. What I have been telling my clients is that you still need to offer the option for owners to come and pick up a ballot on the day of the election and submit it. But to encourage most of your owners to vote via proxy, electronic ballot, absentee ballot, so that even that number is minimal. But for those people that are voting in person, what most of my associations have done is say, let's say your meeting's at 7 p.m. So the manager or board member who's not a candidate, whoever that person is, sits in a lobby or at a board member's house or whatever is convenient for a 2-hour period, 5 to 7 beforehand, right? You can come check in, get a ballot, submit it, put it in the sealed ballot box, and then that will eventually be given to whoever's counting the ballots at 7. So you want to make sure that you have that option. With regard to proxies, that's the way that your owners are able to vote before the election. Make sure that the proxy holder, in other words, who I'm giving my proxy to, that person has to be on the video call. So what we've said is either designate, again, some owner or board member that is not a candidate as the designated proxy holder for everybody, so that one person gets them, and assure your owners that the proxies votes are going to be counted as is. In other words, if I fill out my proxy and vote for John, Bob, and Sue, that's how my proxy is going to be counted. So I do think you need to consult with the association's attorney to make sure that the notice, the forms, and all of that is correct. But, you know, in April, May, June, we were all delaying our elections thinking that at some point we would go back and be able to meet. It doesn't look like that's going to happen for the near future. So if you haven't had your election yet for 2020, you need to start planning it. And the best way to do that, talk to your attorney, talk to your manager, and let them help you develop a process, because it is somewhat of a hybrid and there are going to be some changes.
Is it appropriate to have a process that excludes proxies so that everybody has to vote electronically or drop it off?
So electronic ballots are going to be the same as electronic notice. Owners have to opt in order to use it. The other trick is that for condos, in order to use electronic voting, those rules have to be adopted 120 days prior to the election in which they're going to be used. So, you know, you've got to think about it ahead of time. If you're going to adopt electronic voting in a non-condo, those can be adopted whenever. You don't have that 120-day requirement, but you cannot eliminate the in-person voting option. And if your declaration and bylaws allows for proxy use, which 99% of them do, the only way to get rid of proxies is to amend your declaration or to adopt absentee ballot or electronic ballot processes or rules. So again, my suggestion is to have, consult with the association's attorney so that they can walk you through what that looks like. But these are all options, and they do allow the board to proceed with elections, even though we can't meet in person.
Okay. There was a question here that I'd like you to get to, please, both of you. And this has to do with, I think, in a way, the Palm case. The question is, please state the rules related to meeting in private versus including owners. Boards seem to still think they just need 4 public meetings a year. That was the question, a comment. I'm not sure how you want to respond, but I think in general, this is a good topic to cover now.
Danette, you want to take it away?
Sure, I'll start. I mean, most boards do have to have at least 4 meetings a year, but that is to just approve business items, to invite their membership. Boards meeting in private is still very specific to executive session items. The board can't meet and conduct business just because they've already had those 4 meetings per year. They do have to still meet in open session and invite the membership and give notice to the membership as they did with meeting 1 through 4. But it's very specific to what the board can meet privately about.
Thank you. Kerry, anything else to add?
Yeah, no, just to tag on to what Danette was saying. So all board meetings are open. per the statute, unless you're meeting to discuss, not vote, but discuss one of the 6 topics that are appropriate for an executive or closed session of the board. And so there really should be no private meetings. And as Danette said, the 4 meetings is just the minimum number of board meetings that you're supposed to have per year. I'll go ahead. I'm going to list off what the executive session or closed session topics are. But if it is not one of these 6 topics, it better be discussed in an open meeting. So those are litigation, either pending or probable, to discuss violations of the rules and regulations, to discuss delinquencies, foreclosures, bankruptcies, that kind of thing, to discuss the appointment, employment, engagement, or dismissal of an employee, independent contractor, agent, or other provider of goods and services, and then also interviews related to those people, and then finally to consult with the association's counsel or attorney. So those are the only topics that you can discuss in executive session. I will note that sort of the contractor, 2 exceptions, interview and to discuss contractor issues is pretty broad. That was broadened a couple of years ago. But it still doesn't encompass, for instance, your budget workshop that we all used to hold. It has to be related to a specific contractor or specific service being provided to the association.
Okay. How do you recommend boards deal with, in the past, they may have had group meetings prior to the big open meeting to discuss budget issues. How do you recommend that boards handle that?
Danette, you want to take it or you want me to take it?
Well, a budget issue really isn't an executive session item unless they're talking specifically about a contractor, hiring a contractor. But budget discussion in general, in my opinion, is done in an open meeting.
Yep, I would agree.
Okay. There was a question about nominations from the floor. Are they mandatory? Are they optional based on either law or bylaws?
So that question comes up a lot. There's actually no requirement that a board allow for nominations from the floor under either of the statutes. With regard to particular sets of bylaws, I've seen it once or twice, but typically the bylaws are silent as well. So it's really up to the board to establish their election procedures. But once you establish them, you need to follow them. And historically, if your association has allowed for nominations from the floor, you can't just one day say, oh yeah, but we're not doing that anymore. So if you are going to change your procedures with regard to nominations from the floor, either to allow them or not allow them, that should be very clearly stated in the request for candidates that goes out and the notice of the election that goes out, so that owners know whether or not they have to submit their name early or they can do it at the meeting. I will also say that with regard to Zoom elections, the vast majority of my associations have suspended nominations from the floor for this year. And the reason, again, for that is because it's very difficult to see who's making a nomination from the floor, who's seconding it, is the person accepting it. It becomes very cumbersome on a Zoom call. So if that's what you're going to do, again, it needs to be clearly stated in the call for candidates, and it needs to be clearly stated in the notice of the meeting so that owners know that they have to submit their candidate application ahead of time.
So if I could summarize, just as a board member listening to this conversation, if I could just summarize, is it correct to say the following? Homeowners associations and condo boards are okay to do it either way, meaning you can or cannot, in either case, have or have not nominations from the floor. But if you do or don't, you have to specify clearly in your call for nominations and in your agenda, I guess, or meeting announcement that you are or are not having nominations from the floor.
That's correct.
In other words, it doesn't have to be a declaration or a bylaw change or rules change. It just is an announcement.
Yeah, I mean, here's the so how it works, right? The owners have to know what they have to do, right? So if you're allowing nominations on the floor and I want to be a candidate, well, I don't necessarily have to submit it by the deadline to be included on the proxy because I want to wait until the meeting. If that option is not available, then I need to know that so that I can get my candidate application in time. So as long as we're notifying the owners, then the board can really adopt whatever reasonable procedures they want with regard to the election.
Okay. Going back to Danette for a minute, I have a question here in my own head and also a couple that have popped up on the sidebar. Has to do with what's the best way to handle. Suppose there's a big project that a couple of board members have discussed or other people have discussed over time, or even owners have brought to the board that, maybe we need to look at this as a long-term. Okay, how does a board get around the PALM concerns sufficiently to have any kind of way to discuss that, at least preliminarily, before any decision's made, just to flush out the facts? Is it better to defer that to a committee where maybe there's one board member or ask the manager to handle a discussion with the board member? What do you recommend, Danette?
I think if it's a large project that's going to require a lot of investigation, that the board should probably, if they have the ability and they have residents that are to appoint a committee in place with a couple of interested board members running that. I don't recommend that you have a quorum of the board on that. I think you need to have less than a quorum of the board. Otherwise, you will have to have open meetings every time you discuss it. But it will be an avenue for that group of individuals to really dig down deep into that project and then report it back to the board so the board feels more informed about what direction they want to take.
Kerry, would you agree with that?
Yes.
Okay. Well, that's, I think, a very helpful response because, any business has to do planning and you want to do it in a legal fashion vis-a-vis the PALM case, et cetera, but it doesn't obviate the board's need to do its due diligence. For instance, things like, oh my God, the trees are overgrown. What are we going to do about them? You just can't have that discussion in 15 minutes at a board meeting. I can imagine the cacophony. So I hear you. It sounds like the best way to handle that is to defer that discussion to a committee, have the committee flush it out, have one board member be on the committee, and then bring it all back to the board, correct?
Correct.
Okay. I hope that answers the question for the people that have asked this on the side. Well, we are at 1 hour and 52 minutes into this hour, or 52 minutes into this hour anyway, at 1:52 p.m. And I'm a believer in finishing on time to respect everybody's time. So I'm going to ask each of the panelists to kind of sum up where we are and kind of wrap up today. And then if there are any other questions come up in the last couple of minutes, I'll try to address those to one of you too. So Danette, if you want to try to wrap up what today's discussion meant for you or what you wanted to leave on the table.
Sure. I think we've come a long way since March. I mean, when March happened and we shut down, none of us really knew how we were going to conduct business for our associations. So if you haven't had the virtual meeting or you're nervous about doing the virtual meetings, I think you just need to jump in and do them. We were all on the same footing when this started. Nobody really knew. We were all kind of faking it to make it work. But now that we've had several months under our belt, I think we've seen that it can be very successful. It can really help keep things moving. The residents can see that the board is still actively working, that the staff is still working, the management company is still working. And I just think you don't need to be afraid of those virtual meetings. Have as many of them as you like. You just become accustomed to it.
Okay. Kerry?
Yeah, I mean, just to kind of tag on to what Danette said, I do think that boards have been incredibly, for the most part, adaptable and move their format to Zooms. I'm also finding that owners are very understanding of the limitations on the board. You still have the one or two who are not going to be happy no matter what you do. But for the most part, owners appreciate that the board is still operating, the association's getting taken care of, and I've seen increased participation. Maybe that's a bad thing, but for most people, it's a good thing. And to really get in your comfort zone. But it is, look, as we are all navigating this together, it is novel not just for the scientists and everybody else, but it's novel for board members, for managers, for your attorneys. And the rules keep changing, right? So I think it is important for boards to continue to use resources like your attorney, like your manager, CAI, because you're not doing this on your own. But for the most part, from a legal perspective, meetings, annual meetings, board meetings are going to be the same. It's just being presented in a different format.
Okay. There was one last question about meeting minutes. We really haven't touched very much on that. We probably should as we wrap up. So let's spend the last couple minutes talking about minutes.
All right. I think, Danette, you were going to talk about some...
Sure. Yeah, I did attach the agenda at the bottom. I see kind of some of the chats that have been coming up frequently, and it's about accepting prior minutes. I do think that each board meeting, you should be approving the minutes of your past meeting, whether it be last month's meeting or a few months prior. So definitely all board meetings should be approved at an open meeting. Any motions of any business that you need to transact should be approved at your meetings. I recommend to my boards that we have 2 separate agenda items for discussion items and another agenda item for business items. This way it's very clear which items are just up for discussion. There really isn't anything to be approved that day, but maybe just more informative. And then the other agenda item would be the items that you're actually approving and making motions on. All motions should be part of your minutes. I am not a supporter of putting a lot of context in there with discussions or comments from residents, or it should really just be your motion. What I like to include in the motion is the dollar amount, the vendor, and the contract date time. Other than that, sometimes we'll have committee reports. And then at the end of the meeting, we'll have the executive session if needed. We'll make a call for that. And then, of course, you always need to have your motion to adjourn. And I like to indicate the time that the meeting ran. Do you have anything to add to that, Kerry?
Yeah, I totally agree with you. And I am also a proponent of less is more in your minutes. Minutes are not your newsletter. So you shouldn't be including in your minutes discussion items where no action was taken. That's not the point of the minutes. You keep in mind that the minutes are the business record of the corporation. And so they need to just be about what business was conducted. I also, just to tag on, Danette referenced executive sessions, and we've talked about it on and off throughout our seminar, but there was a recent case in Illinois that talked about whether or not there needed to be minutes kept of executive session meetings. So to give you some context, the statute was changed so that an executive session meeting of the board to talk about one of those 6 topics we discussed can be held on its own. In other words, it can be a standalone meeting, and it does not, under the statute, require notice to the owners because it's confidential. So the question was, if the board holds an executive session, do they have to have minutes that they met? And what the case held was that, yes, they do. So if you have a standalone executive session, you need to keep minutes of it. It needs to tell you, same as Danette said, the date of the meeting, the time it was called to order, who was present, that you had quorum, And then the meat of the meeting, I'll get to in a second, and then the fact that it adjourned. So what goes into the meat? Well, there's no decisions being made. So if you take what we just talked about, that the minutes are just a summary of the motions made and decisions made, there's nothing in those minutes. But what you do need to include in the minutes of an executive session meeting is which one of the 6 topics, one or more, I should say, did you discuss at that meeting? That's all that's in those minutes. So it could be, meeting held on December 7th at 2:00 to meet with the association's council. And then it adjourned at 2:00. So you do need to keep those minutes of executive sessions. The executive session meeting minutes, if you have standalone executive session meetings, will be approved at your next open board meeting. So they are approved along with any other board.
Your screen or sending them out for review to owners, the minutes.
Yeah, but it shouldn't, you're not going to have any meat in it, right? So all it's going to say is, we had an executive session meeting to discuss violations, to discuss delinquencies, but there's no specific information. And those executive session meeting minutes do become part of the record of the meeting in which they're approved.
A couple of questions as we wrap up here, just to wrap up the whole hour. On the issue of minutes, first of all, if you have a website, should you be posting all of your minutes, including executive session minutes?
I'm okay with posting minutes on a website as long as the website or the access to those records is protected and behind a password.
Owners only.
Owners only.
Right.
And it same goes with financials. Yeah. Oh, yes. Good point. Yeah. And they have to be only the approved minutes, not draft minutes.
Right. Another question about minutes and about recordings. I've heard of a number of associations that record meetings, and I take it, I've been told it's legal to do so. The question is, when you do record, do you recommend it? B, do you not recommend it? If you do recommend it or allow it, what do you do with the recordings?
So I'll give you the legal parameters, but so under both statutes, any owner has a right to record the open portion of any board meeting or owners meeting. So we cannot stop it. You can develop rules on how and where that's done. In other words, a guy can't put the video camera or stand right in front of the room and block everybody else. It can't be disruptive to the meeting, so on and so forth. But if that happens, if an owner says that they want to record it, it does need to be announced to the board, and the board needs to announce it to everybody else in the room. Unfortunately or unfortunately, I've had situations where somebody's turned their phone recorder on and they go, "Ha, I recorded you saying blah, 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 blah." Well, that's not going to be legally admissible in any circumstance because there was no notice about it. If you have somebody recording a meeting, you need to absolutely make sure that it is turned off up until the meeting starts, and it is turned off the minute the open meeting ends. We've had several conversations that get recorded talking amongst the board after the meeting's over, and it's usually not good for the board. So make sure that that's turned off. And then finally, under no circumstances, never, don't do it, it's a bad thing, should you record an executive session meeting. Those are discoverable by the other side, and there's no reason for those to be recorded.
Okay. What do you tell boards that may ask you if the board wants to record the meeting?
For their own use?
Well, I'm thinking here just for documentary purposes and for help with minutes, et cetera, et cetera. What do you tell boards?
I don't recommend it, but I do have 2 boards that I know of where they do record the meeting. The secretary records it, and it is immediately erased once the minutes are prepared.
Kerry?
Yeah, I agree. The same.
Okay.
Same.
Very good. Well, I don't have any other questions, and it's 2:04 p.m., and I don't think we're having any other questions come up right now that we haven't addressed in one way or another. So unless either of you have anything else to say, I'm fine with terminating this discussion.
I think I'm good. Yes. Thank you.
I would like to thank both of you very much for participating and helping educate board members like myself and other managers, et cetera. I think that's very helpful. And once again, I said this is the reason I joined CAI to learn more how to become a better board member. So hopefully we're helping other board members and managers along these same lines. Kerry, I'd like to thank you very, very much. Danette, thank you very, very much. And I'd like to thank Brandon and CAI for helping put this on. One last thought. There are those takeaway handouts that Kerry and Danette have prepared. And I think the CAI has prepared a methodology for you to download that. I think it involves giving your email address, and they will email these to you. So please take advantage of it if you'd like. With that, I'd like to close the meeting and say thank to both of to everybody for attending, and especially to Danette and Kerry. Thank you much.
Thank you.
Bye.
Okay. Bye-bye.
Bye, guys.